Okay, so thank you for joining us today. I'm Joe Kennedy. I'm a senior fellow at the Information Technology and Innovation Foundation, and I'm pleased to have everybody participating in this event. Just a couple housekeeping announcements. As the people joining us remotely know, we're live streaming this event, and those those watching on the other end should be able to see a link to my slides as I present them, so that you can see the slides as I'm describing them. We encourage everybody to please follow ITIF on Twitter, and for this particular event, we're using the hashtag ITIF Antitrust. We'll keep an eye on that hashtag in case anybody wants to ask questions during the Q&A portion of that at the end of this program. Briefly, I'm going to present a paper we're releasing today, and then I'm going to turn it over to a panel of three distinguished members or people, and I'm going to introduce them now in the order in which they are sitting and also the order in which they'll speak. William Reinhart is Director of Technology and Innovation Policy at the American Action Forum. He specializes in telecommunications, internet, and data policy with a focus on emerging technologies and innovation. He comes to the forum from Tech Freedom, where he was a research fellow, and he also previously was the Director of Operations at the International Center for Law and Economics. In 2009, Will was a Koch Summer Fellow at the Progress and Freedom Foundation, concentrating on advertising policy and Internet governance. He's currently a fellow at the International Law and Policy Foundry, and additionally he serves on the FCC's Broadband Deployment Committee and its Consumer Advocacy Committee. Charlotte Layman, Policy Counsel for Public Knowledge. Prior to joining Public Knowledge, she worked as in the Anti-Competitive Practices Division of the FTC, investigating and litigating antitrust conduct violations, including the 2017 case against 1-800-CONTACTS for manipulating Google search and ad auctions. She also previously worked as an LA to Senator Franken, focusing on the Judiciary Committee. She received her JD from New York University School of Law and a BA in Government from the University of Virginia. Carol Shapiro is Professor of Economics and Transamerica Professor of Business Strategy at the Haas School of Business, UC Berkeley. He had the honor of serving as a Senate-confirmed member of the President's Council of Economic Advisors, and twice served as Deputy Assistant Attorney General for Economics at the Antitrust Division of the Department of Justice. He's been co-editor or editor of the Journal of Economic Perspectives and a fellow at the Center for Advanced Study in Behavioral Sciences. He earned his PhD in economics from MIT in 1981 and has been a member of the faculty at UC Berkeley since 1990. He's published extensively on the areas of industrial organization, competition policy, patents, the economics of innovation, and competitive strategy. He's the co-author with Hal Varian of Information Rules, a strategic guide to the network economy, which helped many of us sort through the ideas attached to information as a product and the information economy in general when the internet was just going. So our report, why the consumer welfare. Our report, why the consumer welfare standards should remain the bedrock of antitrust policy, was motivated by increased calls from some advocates for a fundamental change in antitrust law. This change, if implemented, would take antitrust in a radically different direction, a direction that was tried before and did not work. It would prevent the growth of large companies even if there was no harm to other market participants, and even if their success had resulted from more efficient production and lower prices. I hope to convince you that the principles guiding current antitrust policy are sound. They're built around the proposition that most business actions, including mergers, should be judged by whether they will result in economic harm to consumers or the rest of society. This requires a detailed economic analysis of the specific markets in question. This standard has given courts, regulators, and companies firm guidance on both the standard for making decisions and the type of evidence decision makers should consider. It would be a mistake to abandon this practice in pursuit of policies that transform antitrust policy into an all-purpose weapon for solving today's problems. In this talk, I'll cover 6 topics. The first is a summary of current antitrust policy and its consumer welfare standard. Second, I'll briefly describe the so-called neo-Brandeisian movement, which alleges that past policy, and specifically the consumer welfare standard, has allowed too much concentration within markets, resulting in clear harm to the economy and society. The neo-Brandeisian objections can be put into 3 categories. The consumer welfare standard already handles the first category. From the neo-Brandeisian view, what we need is a new standard, not a new standard, but a more aggressive application of the current one. The second set of objections involve legitimate policy issues, but policies other than antitrust are better placed for dealing with them. Again, neo-Brandeisians may feel that these policies need to be tougher, but that's different than arguing for a wholesale revolution in antitrust policy. Finally, there are some cases where what the neo-Brandeisians want would impose significant losses in consumer welfare, economic growth, and the pace of innovation. These should be rejected. Finally, I'll summarize with arguments for keeping the current standard as our guidepost. For the last 40 years, roughly, antitrust policy has been guided by the consumer welfare standard, which says that a business practice, including a merger, is anti-competitive if it disrupts the competitive process or it results in harm to trading parties on the other side of the market. It looks at whether a particular activity gives a company enough power to raise prices, reduce quality or quantity, or otherwise harm market participants. Absent such harm, the government usually does not intervene. Adoption of the standard was encouraged by the development of clear theoretical guidelines by scholars such as Robert Bork and Richard Posner. But another reason for its wide adoption was the common feeling at the time that the current practice of attacking bigness per se was too vague and was harming the economy by discouraging companies from becoming more efficient or competing on prices. Although almost all antitrust practitioners support this general thrust, there are active debates about its implementation in specific cases. As we'll hear, some supporters feel that it has been applied too loosely in the past and would like to see more mergers challenged because they believe consumers are being harmed. There's also disagreement about the standard scope. In evaluating mergers, some groups would only credit benefits that consumers actually receive, whereas others are less concerned about who benefits from competition policy as long as total welfare is increased. Lately, however, a number of advocates have argued that the standard is incapable of dealing with a wide range of social problems. They argue for a fundamental restructuring of antitrust law. The new movement resurrects the arguments of presidential advisor and Supreme Court Justice Louis Brandeis. Brandeis argued that bigness itself was a curse, leading to a broad range of social ills. Antitrust law should actively prevent companies from having any meaningful market share, even if their success came from raising efficiency and lowering prices. In fact, he was deeply skeptical of both of these as goals for competition policy. Today, several people on the left echo these concerns. The slide contains several quotes. I'll read just one, where Senator Elizabeth Warren recently stated that today in America, competition is dying. Consolidation and concentration are on the rise in sector after sector. Neo-Brandeisians claim the consumer welfare standard has hurt people by allowing large firms to dominate markets. These companies use their power to drive competitors out of business, to squeeze their suppliers, including workers, and to harm consumers by either raising prices or cutting quality. They believe the focus on consumer prices detracts regulators' attention from non-price threats, and that the focus on consumers ignores the possibility that market power can be used against suppliers, including workers. To prevent these harms, government should oppose mergers and some other forms of competition even before any alleged harms are proven. In fact, in some cases, they argue that the government should permit higher prices in order to protect less competitive parties. Although the Neo-Brandeisians argue for a radical change in antitrust policy, in many cases their goals can be achieved through the consumer welfare standard. Perhaps their most pressing point is that consumer welfare standard has failed to protect consumers. They argue that concentration has increased in market after market, hurting customers in the process. Yet many of the key studies looking at market concentration focus on broad industry definitions and are measured nationally. But in most markets, concentration remains at moderate levels, and no company has a dominant share of the national market. More importantly, these statistics do not really tell us much about the level of competition where it really matters, when a specific individual tries to purchase a specific good or service. At this level, there is often a great deal more competition. As Carl Shapiro notes in a paper, these studies just seem to assume that higher concentration has harmed consumers. But there's little actual analysis to back this allegation. National markets have become slightly more concentrated. This is largely so that they could become more efficient and has not usually resulted in a meaningful decline in local competition. Consider what would happen if a small town started with 4 locally owned restaurants. Let's assume that over the next decade, 2 were purchased by national chains, and a third national chain set up a new restaurant. If this happened in many towns, the industry as a whole would become more concentrated at the national level. But citizens in each town would now have 5 choices rather than 4. The case is instructive because Neo-Brandeisians would lament the change, claiming that the town had lost something valuable in the decline of local control. But the movement merely reflects the growing role of large firms in the national market, telling us little about either the degree of competition where it matters or broader trends in market powers. Neo-Brandeisians also argue that the current focus on consumer prices ignores a variety of non-price harms that can result from market concentration. These include deteriorating quality and less variety. However, the current government guidelines for evaluating horizontal mergers make it clear that the analysis of potential markets often looks at pricing power for simplicity of exposition. Regulators look at whether a transaction could result in enough market power to raise prices, but they recognize that that power could also be expressed in a variety of non-price ways. What is important is whether the power exists, not how it's expressed. A specific type of non-price harm is a threat to innovation. Neo-Brandeisians claim that the growing market concentration has led to less innovation. Firms with significant market power may feel less pressure to improve their performance and therefore may invest less in research. Second, dominant firms are in a position to spot potential threats to their power and can easily buy up small competitors. Yet it's clear from the last slide that the consumer welfare standard can handle non-price threats, such as that to innovation. Again, the government's horizontal merger guidelines include a specific section on innovation and product variety, and clearly list innovation as a potential non-price threat regulators need to watch out for. Recently, the government has opposed a number of mergers on the ground that they would reduce the incentive for one of the parties to develop innovations aimed at the other. In fact, far from harming innovation, in some ways large companies can actually spur it. They are often the best source for the knowledge, capital, and marketing expertise needed to take promising innovations to scale. They take advantage of the efficiencies of scale associated with national and international markets and often benefit from network effects. These advantages produce higher margins that the company can then plow back into research and development. According to data from the National Science Foundation, larger companies spend a higher proportion of their budgets on R&D. Neo-Brandeisians also worry that the concentration on consumer prices blinds regulators to the fact that market concentration will be used to squeeze suppliers and harm workers. They point out that economic inequality has grown over the last 4 decades, partly because of slower growth in worker compensation. But despite its name, the Consumer Welfare Standard also protects other market participants. Companies are not allowed to use market power to unfairly drive down the prices of their suppliers. Nor can they conspire to take actions that would reduce labor costs by limiting competition for workers or holding down pay. The government has taken action against agreements by companies not to poach each other's workers. More recently, several large fast food companies agreed not to enforce non-compete agreements that had prevented their workers from accepting jobs at other sites within the same franchise. Their size and visibility have made the large internet platforms a common target for Neo-Brandeisians. They believe these companies have too much power over users and face little threat from competitors. This ignores the fact that these companies compete fiercely in the ad market. These companies also create significant innovation in markets as diverse as automated vehicles, broadband coverage, space flight, and cloud computing. These companies get much of their profits by operating market platforms. The basic role of a platform is to reduce transaction costs by bringing together 2 or more sides of a common market and helping these sides reach an agreement. Platforms pose 2 related tests to traditional antitrust theory. The first is that it is difficult to argue that consolidation will harm consumers if they're getting the service for free. Neo-Brandeisians challenge this rationale by arguing that consumers suffer from non-price harms, including the need to give away large amounts of their personal information. Second, the practice of pricing below marginal cost has traditionally been regarded as a per se antitrust violation. This view is slowly changing and makes little sense in the case of a platform when low or zero costs are needed to attract one side of the market. In general, traditional antitrust policy, including the Consumer Welfare Standard, is capable of dealing with platforms. But the interrelationship between each side of a market requires regulators to investigate how company practices affect all sides of the market before they take a response. So the Consumer Welfare Standard is capable of handling many of the neo-Brandeisian worries. In still other cases, the problems neo-Brandeisians point to are valid, but antitrust policy cannot deal with them very effectively. We need to develop or strengthen other policies specifically tailored to the problem at hand. Neo-Brandeisians frequently talk about the threat Internet platforms and others pose to privacy. Although the companies provide a valuable service for free, they sometimes gather a great deal of personal information about consumers. Antitrust policy already looks at the unfair accumulation of important inputs, including data. I'll just note that a great deal of data is neither scarce nor sensitive. But it is clear that the use of data can involve important privacy issues. Antitrust is just not the appropriate place for framing privacy policy or enforcing it. Separate rules specifically devoted to this issue are more effective. As it turns out, the FTC's Bureau of Consumer Protection, the Consumer Financial Protection Bureau, and the Attorneys General of each state and territory already have significant powers to punish companies if they violate their terms of use, commit clear infractions of privacy laws, or fail to adequately secure their users' data. If Congress wants to strengthen these laws, it can do so, but it should not conflate privacy concerns with antitrust policy. Similarly, neo-Brandeisians also allege large companies pose a threat to democracy. Their size allows them to acquire significant political power and to make donations to politicians and the organizations that back them. This power can be used to capture regulatory agencies and to lobby for enactment of rules that entrench their market power. Again, the threat is less than it is often portrayed. Large companies often oppose each other in antitrust cases and on issues such as net neutrality and tariffs. They also face significant competition from other political groups, including labor unions and organizations that represent the interests of small firms. If advocates want to try to improve the political system, they can regulate campaign finance, political lobbying, and disclosure laws. But antitrust enforcement is unlikely to be an effective tool for cleaning up the political system. In summary, if Congress wants to tighten privacy laws or the political process, it should deal with these problems directly, not through antitrust enforcement. Finally, there are some cases where what the neo-Brandeisians call for is just wrong. Adopting their policies would result in less competition, less productivity, and lower incomes. Louis Brandeis was extremely concerned with the welfare of small local businesses. He believed competition from big business posed an existential threat to the local businessmen running his own company. This in turn hurt hundreds of small communities by depriving them of their economic independence and control over their own futures. Brandeis took it on faith that no big business could get big purely by competing on the merits. Yet many do. Government interference in the market to protect smaller, less efficient companies would reduce productivity and living standards. It should be noted that the market power that local businesses have exerted on small towns has not always been benign. Local consumers often welcome the opportunity for broader selection, lower prices, and easier credit terms offered by national brands such as Sears and Roebuck or Amazon. Brandeis's followers also worry about the fate of workers in a competitive world. The consumer welfare standard protects workers against clear anti-competitive action by employers. But it does not protect workers when their firm loses to competition or implements productivity improvements that make their job redundant. Nor should it. Neo-Brandeisians claim that greater concentration reduces competition for workers in general, lowering their alternatives and reducing their ability to find a better job. They view concentration as a significant factor in the long-term stagnation of worker compensation. For a number of reasons, including technological change, immigration, and freer trade, low-income workers have struggled for the past few decades. Yet consolidation has played little role in income inequality. Although it reduces the number of firms, it does not necessarily reduce the number of total jobs. On average, larger companies pay their workers more and offer better benefits. Their scope also gives workers better career opportunities. Although inequality and wage stagnation are real problems, other policies are better suited to deal with the short-term effects of these problems. These include a more progressive tax system, better education and worker training, and direct supplements to help individual workers in their communities. To sum up, the concerns of neo-Brandeisians can often be dealt with by either making changes in how the consumer welfare standard is implemented, or by the enactment of specific laws dealing with privacy, political campaigns, and economic support. In other cases, neo-Brandeisians are arguing for a fundamental dismantling of the competitive process. We should firmly oppose the efforts to protect small business and workers from legitimate competition. But even aside from these concerns, neo-Brandeisianism as a theory is not workable in practice. The attack on bigness would significantly increase the discretionary power of the government officials. Although not perfect, the consumer welfare standard and the current guidelines give courts and regulators a fairly discrete task to do: protect market participants from discriminatory exercises of market power. They also set out pretty clear markers for the kind of evidence needed to make these decisions. In contrast, neo-Brandeisians would task antitrust with a variety of goals, including protecting jobs in small businesses, spurring innovation, helping consumers, and preventing concentration. Regulators would be responsible for privacy, income inequality, and the decline of local economies. But the theory provides no guidance on how to make these trade-offs. Holding antitrust policy responsible for everything is likely to mean that it accomplishes nothing. But could we even assume that government officials will use this power responsibly? Isn't it more likely that antitrust policy veers widely from administration to administration, as each tries to use these powers to achieve its vision of the proper market structure? What if an administration used the Department of Justice to punish a company that opposed its policies, say on trade? How would private companies react to such uncertainty? And wouldn't regulatory capture worsen if we give regulators more power but leave them unaccountable for any specific goal? In summary, there are many reasons why we should not abandon the current consumer welfare standard. It provides over 4 decades of valuable guidance to courts, regulators, and companies on how the law will be applied. The standard remains flexible enough to deal with market changes and can therefore adapt to the need for lighter or tougher enforcement over time. Most important, the standard focuses on actual harms that antitrust is capable of fixing, not on unrelated problems that it has little power to correct. In doing so, it preserves the creative destruction that drives productivity and higher living standards. The Consumer Welfare Standard focuses on the interests of the majority of Americans. We should be hesitant to discard such a strong consensus in favor of a failed theory from America's past. Thank you, and I'll now transition over to my seat where we'll hear from the panelists.
That 30-second transition time period where we stay silent for a second. So thanks.
Reflect on the brilliance.
Yeah. So thanks, Joe, and thank you, ITIF, for having me today to talk about this, I think, a very important issue. I really want to talk today a little bit about antitrust effects writ large and some of the studies that have existed now for something like 40 years on this relationship between antitrust as a policy, competition policy writ large, and its actual effects. We often talk in this conversation about Standard Oil and AT&T because they're two they're two well-known cases about kind of a strong antitrust enforcement of breaking up companies and trying to reinvigorate competitive markets. But I want to focus on a case that we don't talk about as much, and that's American Tobacco. Now, this case started in 1907 and was finished in 1911, and it is, I think, probably pretty indicative of the kinds of cases that we would likely see today if we were to take a more restrictive approach or a more onerous approach when it comes to antitrust. On this case, I think actually historian Alan Brandt described it best when he described this breakup in the Cigarette Century, which is a great book, actually. And he noted, it was one thing to identify monopolistic practices and activities and restraint of trade, and it was quite another to figure out how to return the tobacco industry to some form of regulated competition. Even those who applauded the breakup of American Tobacco soon found themselves critics of the negotiated decree restructuring the industry. This would not be the last time the tobacco industry would successfully turn a regulatory intervention to its own advantage. Now, the effect on the market after American Tobacco was broken up wasn't as many people had hoped. The new companies really didn't compete on prices. Real cigarette prices, for example, remained stable for the next couple of years. The prices paid to farmers also didn't change that much. In short, the competition that we wanted, or that many regulators had wanted, didn't really come about because of this case. Part of the reason, of course, and the reason why I'm bringing this up is because American Tobacco is a little bit different than the normal businesses and companies that we talk about when we're talking about AT&T and Standard Oil for breaking up companies. And the real distinction between the two is that American Tobacco by right around 1900, they had merged three major previous companies, and the hope with this case was to kind of break them back into these original three companies and therefore create competitive markets again. Well, what happened in the interim was that the organizer of American Tobacco had basically mixed everything. So all of the processing plants, all of the financial offices were all merged. And what you had at the end of the day was what you might call a unitary organization. It was not like Standard Oil in that you had somewhat local offices dealing with finance and with billing. It was all centralized. This is the kind of firm that we're talking about when we look at, for example, Apple. Apple is very much this type of organizational firm. It has one specific division that works with finance, one that works with engineering, whereas when you look at, for example, Standard Oil and AT&T, they were far more geographically separated. They had local offices. Now, this isn't perfect, but I think it highlights the distinction between the kinds of companies and the results that occurred when you had an antitrust case applied to them. I know that a lot of people have been wanting to use antitrust and competitive policy as a way to kind of reinvigorate markets and competitive markets, and I would offer some caution because we've been doing this for quite some time. We've been at this for almost 100 years, And for the last 40 years, the FTC and the DOJ and economists have been working quite extensively, including the distinguished economists here on the panel today, have been working to try to understand the competitive effects of antitrust cases. And we've come to realize, obviously, as Joe had mentioned, that that the evidence suggests more concentration within specific markets, but it doesn't necessarily mean that the antitrust policies that we would want to enact would result in a better competitive outcome. We won't necessarily know if we'll see higher productivity or if we'll see better prices. And we really see this through kind of the retrospective merger analysis that has been conducted for so many years. So to highlight a couple of these studies, I just want to go through what we've seen so far. And what we really see is that retrospective studies really present a muddled picture. There are some cases where it seems that stopping a merger might have actually kept prices low. In other cases, it's kind of unclear. So, for example, a retrospective of the Maytag-Whirlpool merger found that it actually led to substantial price increases for clothes dryers, but did not lead to price increases for clothes washers, interestingly enough. A review of hospital mergers basically found that the price effects differed substantially across regions and localities. Post-merger price increases have been found in academic and legal journals and in airline markets, but then studies of the drug industry and the oil sector have basically found null effects. In the banking sector, you've also found positive increases because people now have access to more capital when you have mergers. So what we see really with these retrospective merger studies is what we would expect to see, which is that context matters a lot, the industry matters a lot, the firms that are merging matter a lot. And I just want to focus, or at least end this conversation on my end right now by highlighting what I think is probably the most important thing here, which is that policy and antitrust policy really should be focused on dissipating rents rather than trying to tax rents after they occur. What it really should be focused on is ensuring that the most harmful mergers and actions do not occur, rather than trying to tax companies at the end of the day when they have actually become successful. And I look forward to the questions, but at the end of the day, I think that we need to do better, just generally speaking, on the kind of analysis that we're engaging in here.
Charlotte?
Great. Well, thank you very much, Joe, and thank you to ITIF for hosting this discussion today. I'm really glad that we are having this discussion and discussions like this throughout the sort of antitrust community. And I think we were not having this discussion about the consumer welfare standard a few years ago. So that's great. But I am not convinced that we need to replace the consumer welfare standard. But I also don't believe that the economy is functioning the way that we would like right now. So I do think we need to improve antitrust enforcement within the consumer welfare standard, and I also think that we need improved regulation and increased regulation in a lot of these industries. So it feels a little weird to be defending the consumer welfare standard since it has so many defenders. But one of the things that I think, there's a few specific points about it that I think are important reasons that we want to keep the consumer welfare standard. One is just that there is this bipartisan consensus on this sort of basic baseline of antitrust, which is really valuable and not to be taken for granted. We find in new administrations that so many important policies are immediately on the chopping block. And so having a bipartisan consensus behind this, something that we know will continue into the future, is valuable and should not be lost. I also think the consumer welfare standard is more flexible than it is given credit for. There is definitely a problem where antitrust analyses are often too focused on price. I think that's because the economic modeling on price is easier and there's more background there. But it really is supposed to also care about quality and innovation. And I think we need to do more to make those priorities count, but the consumer welfare standard can do that and should do that. Last, the consumer welfare standard is dynamic. It can incorporate new economic learning, and I think that's really important. We don't need to go through a long regulatory or legislative process to incorporate new economic learning. Just yesterday, there was a Senate Antitrust Subcommittee hearing where senators were saying labor markets are not being sufficiently considered in merger review. And I think that's absolutely right. For many years, labor markets have not been sufficiently considered in merger review. And Chairman Simon said, well, we are now telling the FTC attorneys that in every merger review, they should be considering labor markets. And that's something that we can do with the consumer welfare standard when there's new economic learning that needs to be incorporated. But there are indeed problems in the economy. One that I think often is not talked about enough is the drop in entrepreneurship. I think a lot of people agree that there has been a drop in entrepreneurship, and that's a real problem. It's not yet clear to me that that has been caused by lax antitrust enforcement. I think VCs, venture capitalists, have been saying sometimes explicitly that they only want to fund companies that are, in a certain line of commerce where they're likely to be bought by one of the big platforms. So that could be discouraging entrepreneurship in other types of industries, and that may or may not be because of antitrust. And VCs, I think we see, are commonly funding startups only in a certain few cities. So there are a lot of causes to this fall in entrepreneurship, but that's something that we should work on and try to improve. And Will, I'm glad that you mentioned these merger retrospectives. I think that that's a really important way that we can learn about how antitrust is working for the economy. The Quokka study back in 2013 showed that many of the mergers that have been approved by the agencies actually did end up leading to increased prices. So I don't think we can say everything is going great and perfectly. We definitely need to keep working on improving antitrust. And I think although large firms may spend a lot of money on innovation, as Joe mentioned, if your innovation is happening largely at large firms, you definitely risk that they may shut down disruptive innovations. I think that's the story of Bell Labs, that there was so much great innovation going on, but any innovation that was going to disrupt their monopoly, they could just shut it down, and in some cases they did. So I don't think that that's a sufficient source of innovation. And I think Americans understand intuitively that corporate power is behind a lot of the inequality that they're facing today. So there will be political power behind that, and I think we should take that seriously and incorporate that into our policy prescriptions. So what should we do? So I do think that we need to take quality and innovation more seriously within the consumer welfare standard. There's this story about the man is looking for his keys on the corner, and you say, is this where you dropped your keys? And he says, no, but this is where the light is. So I think that's what we're doing with price. I can't claim that analogy, but I think that's what we're doing with price. We have good models to analyze price. And what we need to do is build a lamp over by innovation and quality. So I think we need to put more effort into identifying a real framework that can analyze seriously quality and innovation. And I'm not saying that will be easy, but we should get started on working on that. And then we do need to actually regulate these issues. I'm so glad to hear from these panelists that you agree that we need more regulation, and I'll look forward to working with you on that. Excuse me. So at Public Knowledge, we're particularly focused on technology industries. So I don't want to comment too much on what types of regulations may be needed to help with labor concerns. But I do think the dominant platforms play a really important gatekeeper role that, if it cannot be addressed through antitrust, definitely needs to be addressed through regulation. You mentioned that Joe, you mentioned that they compete fiercely on advertising, but that leads to sometimes privacy violations. It leads to a business model that a lot of people find harmful, where you're sort of must be constantly engaged in the phone because that is better for advertising. And the profit motive there is not compatible with what we think is best for consumers. And so that's a perfect situation where you need regulation instead of antitrust. If we had 3 Facebooks, would one of them decide to be more pro-privacy, or would they all just follow the same business model? There needs to be some baseline of regulation to deal with that. And I don't think that's revolutionary, right? I think the Cable Act of 1992 is a great example with the program access and program carriage rules. We can address dominance through regulation if antitrust is not the right way to go. Thanks.
Great. Carol?
Good morning, everybody. Hope you can hear me, see me, sort of. I appreciate that I didn't have to fly across the country for this. Thank you, ITIF. I've been writing about this recently. It's got the Consumer Welfare Standard, and whether we should do more with antitrust has gotten a lot of attention in the press, especially the last 2-3 years. If you want to know more about my thoughts, I have a paper called Antitrust in the Time of Populism that's been, I think, well received, and I think Joe cited it. It's on my website here at UC Berkeley, and I testified in front of the Senate Subcommittee on Antitrust last December. And I want to actually start there, since we're talking about the Consumer Welfare Standard. I think one of the problems is it's not a very good label. It's kind of misleading to most people because it makes you think all you care about is consumers. What are the workers, for example? Okay, what are the other suppliers? Okay, so but in practice, it doesn't just mean consumers. Okay, so I'll just read from what I told the Senate and how in my use, and I'm not alone on this. The Consumer Welfare Standard means that a business practice is judged to be anti-competitive if it disrupts the competitive process and harms trading parties on the other side of the market. Now, if you have a cartel that raises the price of a consumer product, it harms the consumers. But if you have a cartel or another practice that causes workers to be underpaid, that fits within this standard as well. And in fact, when I was DOJ, we brought this no-poach case against companies who were reaching agreements to not hire each other's workers in the tech sector. Okay, so it's not just about consumers. That's what we're talking about. Okay. Second main point: the folks who've been challenging the Consumer Welfare Standard, they have in mind, I think, many other social concerns besides competition. So I start from and again, this is from my Senate testimony, but I think it's a durable, important point. The proper goal of antitrust is to promote competition. Okay. Obviously, there are many other public policy goals out there. Okay. But if we're talking, and I think what's enlivening this, the critics of the Consumer Welfare Standard is concerned about the political power of large companies. I'm very concerned about basically corruption writ large in our government, particularly in the federal government. They're concerned about small and local businesses. It's long been a concern in America, who suffer from competition from larger companies. They're concerned about inequality of wealth and income, and they're concerned about workers. Okay, but particularly most of those things are outside of competition. Okay, so. And there's plenty of regulations. We can have campaign finance reform. We can have other forms of regulation to protect privacy or and so forth. So if we think I just think trying to do everything with antitrust is a mistake and it'll be muddled. And Joe said the same thing. Okay, so if we focus on the goal of protecting competition, then I think we have two main questions. I'd like to distinguish two things that are going on here in the debate. First, this big question: do we need to radically change the way we do antitrust and move away from the existing jurisprudence, which focuses on, like I said, whether practices harm competition, to some other standard? Okay. And then a second question would be, can we work within the existing standard to do more if we need to do more or change things? Okay. So on the need for radical change, okay, my answer is no, we don't need radical change, and abandoning the methodology, the basic approach we've taken for a long time. You might ask yourself, this is an interesting situation. We've got basically everybody, I would say, who's been involved actively in doing antitrust for the past 40 years, across a wide range, and with bipartisan consensus, has accepted this framework. We work within this framework from very different laissez-faire to rather interventionist, aggressive folks. Okay, and all the people who are, let's call them the experts in this area, think we don't need the radical change. And then we have some new voices, let's call them outsiders, and that's not a plus or a minus. They're just outsiders who say we need the radical change. Well, what do you make of that? It could be everybody who's been doing this is mixed up in some groupthink and they're hypnotized. Okay, I don't think so. There's been a lot of debate within this group. You can think, if you're coming this from afar, you might ask that. You could think the new folks have some breakthrough. They're just, it's a breakthrough and they found new evidence or a new way of thinking. I don't think that's true either. In fact, a lot of what they're talking about is basically rehashing things that were covered before. I'll come to predatory pricing as a leading example of this. I think instead what it is there's dissatisfaction more broadly with the mentioned things I talked about, political power, inequality. And people look to antitrust, well, can antitrust save us? And since we've got these big social problems, if we're going to do something, we have to do something radical. Okay, but I just don't think it's really very well thought out when you get down to it. A lot of the claims that are being made are just false. Okay, for example, people say, well, antitrust, it's the consumer welfare standard, it only looks at consumers, not at the workers. Well, it's not true. I have in front of me the horizontal merger guidelines. There you go. Yeah, horizontal merger guidelines. I was involved in this, and lo and behold, there's a section about how suppliers could be harmed, and we have an example with farmers, but it could just as well be workers. Okay, so it's not true. Supposedly it only focuses on short-run price. It doesn't think about innovation. Well, sorry, it's not true in terms of the cases. And there's a section, the horizontal merger guidelines, that talks about innovation. Okay, so some of this stuff is just not true. Other stuff is just muddled. So take predatory pricing, which is, I think, and going after Amazon is one of the leading examples that this group has put forward where antitrust has supposedly failed us. Well, you start to look at that and say, all right, there's no question, I think Amazon has brought enormous benefits to consumers, put a lot of pressure on other retailers to be sure. Okay, so that's competition. All right, but we could worry they're getting large, they're getting dominant. Are they pricing below cost? I haven't seen evidence of that, but is this a danger to competition? Well, we have predatory pricing law. We have economics of it. It was worked out a lot in the 70s and 80s. The Brook Group case is the leading Supreme Court precedent. Maybe that should be changed. Maybe it should be widened. I don't know. I haven't been convinced of that. But why would you want to do? I think it'd be unwise to go after low prices as themselves inherently a problem. In fact, it reflects competition, and that's what was the consensus was formed around that 40 years ago. So there's really the leading example put forward by these the folks who really want to change things. I don't think really holds up. If somebody wants to make out I call it a real serious case against Amazon, I'd like to see it, but it hasn't been done. Okay, I suspect it'll be very hard to do. So then the last point, which is what I would rather have us spending more of our time on, actually, is what should we do within the existing flexible framework that has bipartisan support? And I'd be happy to get rid of the consumer welfare label for what we're doing. I would rather something more like protecting and promoting competition, safeguarding competition. Okay, that's what we're about. So should we shift there? And I've been saying for a while, and the evidence I think has continued to accumulate, the economic evidence for 10 or 20 years at least, indicate we should be turning up the dial generally. Okay, if you look at the main areas of antitrust, cartels, there's been a lot of cartel enforcement. There seem to be a lot of cartels out there too. Nonetheless, they're breaking up big cartels. Who knows how many we're missing? So it makes me a bit nervous that maybe we could do more there. I don't have specific recommendations. Certainly I wouldn't want to do less. A lot of these are international cartels, by the way, some of the biggest ones. Mergers, the government has a burden of proof. It can be hard to meet under existing standards. The structural presumption based on market shares is very important for the government, but that can present some hurdles as well. We do have evidence. I'm more in the camp that the merger retrospectives generally show we should be more assertive on mergers, not dramatically so. So we have evidence on this. I would say we should do more. And it's basically how do we empower the government to learn more about mergers that have caused problems and to bring cases and ultimately, have anti-competitive mergers never get out of the boardroom in the first place. So we could do more there, and we can have a debate about that. But there's no reason to depart from the existing protecting competition standard, and that's what the statute says in Clayton Section 7 anyhow for mergers. It has to do with, mergers are illegal if they substantially lessen competition. That's very broad statutory language. And then we have exclusionary conduct by dominant firms, obviously a big issue in the tech industry. The evidence here, the economic evidence that's accumulated, I think shows that we've had growing economies of scale that's led to some consolidation. We probably have higher margins, sort of price versus some variable cost margin. We have higher profits in a lot of sectors. And so all of that suggests that could very well be the results of competition. But it also means we have more market power out there in the sense that the firms that have a strong incumbency position they'll want to protect. So we need to stop them from doing that. So the process of Schumpeterian creative destruction and disruption continues forward. And we really need to be, we don't want firms merging if it's hard to get in because they're big scale economies, we don't want these people who've cleared those hurdles already to merge, or, we want to be more tougher on that. So there's a lot of evidence accumulating that suggests we should be doing more on antitrust, but there's no reason we can't do it within the existing structure of protecting competition using the poorly named but very good consumer welfare standard. Thank you.
Thank you. And I'll just ask if any of the panelists want to comment on anything that the other panelists said.
There's actually one thing I do want to comment on, which is this drop in entrepreneurship. This, to me, is actually a very difficult area, primarily because, in 1978, Robert Lucas basically predicted that we're going to have less entrepreneurism, that as you become more wealthy, there seems to be, and there's some interesting work on this, that there seems to be a tendency for workers to choose, for various reasons, and to choose to be in effectively larger firms, which then kind of disallows, or not disallows, but it, I don't want to say cajoles, but there's this, it seems to be that there's this tendency that when you become more productive, you have larger firms and you have less entrepreneurism. You see this generally with most every large productive country. We have very similar, or at least seem to have very similar entrepreneurial levels as compared to Sweden and Liechtenstein, which has effectively the same productivity standards as the United States. So the question about entrepreneurism is, to me, it's an important question, but I think that when we look at this decline in entrepreneurism, we kind of expected for this to occur already. The question is what, do we care more about firm entry? Do we care more about firm exits? Do we care more about productivity? When we talk about entrepreneurism, there's a lot that's a part of that, and I would just caution and suggest that we need to be very specific about the kind of worries that we have with entrepreneurism.
Let me pick up on that just briefly. I think a lot of firm formation is almost like 80+. That's not a failure of competition, as far as I can see. But these trends are unwelcome to many, and from a social point of view. And there's less local control in a lot of parts of the country because of big firms who have their outlets, or whether it's Walmart, right? So that's not a decline of competition, but the economy is but we might not like it.
Okay, I'll open it up to audience questions. Yes. And then do we have a mic coming? So if you can wait for the mic and. Yep. Okay. There we go.
Hi, I'm Mark McCarthy with Georgetown with Software and Information Industry Association. What a panel! We largely in agreement, and I don't want to challenge that consensus because I think it's largely right. But I want to ask a very specific question about ways forward. I like Professor Shapiro's suggestion that we need to do more, but we need to do it within the consensus framework. One of the suggestions that came from FTC Commissioner Chopra was a new rulemaking in the area of defining unfair methods of competition under the FTC Act. I wonder what the panelists think of that as a possible way forward. Is it likely to be productive or counterproductive? Any thoughts or reflections on that?
Anyone?
Well, I'll jump in. It's hard to not interrupt from this machine point of view here. So Commissioner Chopra mentioned, my main answer to that is, I think it's an intriguing idea that definitely has a place, and I think the FTC has underutilized its authority here for a long time. The question on my mind is, tell me what the rules are that will work and will do what he hopes they'll do, which is provide clear guidance to the business community and be a better process than going through case-by-case adjudication. So his two examples are the pay for delay in the pharmaceutical area and some sort of non-compete clauses in labor agreements. And I'm pretty open to both of those looking pretty helpful to me. I've been involved in the pay for delay cases, and it's taken a very long time going up to the Supreme Court, and it's still kind of not as clear as it should be. So I think those are promising. What I don't know, and I'm mildly skeptical of, I guess, how many other areas one could find rules that would meet the standards he puts forward. You develop an empirical basis for the rule, the FTC promulgates the rule, they have an open process, and it's clear and helpful and avoids litigation.
Yes, sir. Yeah.
Carl Szabo with NetChoice. On the issue of entrepreneurship, we've actually seen an increase in entrepreneurship recently, which makes sense. The internet's enabled small businesses to basically find customers all across the country. Two things for the panel to discuss. One, the benefit of how large entities are actually helping smaller ones. Like my mom has a craft show coming up. She's able to micro-target because of basically large platforms having lots of users on it. So the benefit of large to small. And the second is, with respect to cartels, as you mentioned, Carl, we have a lot of cartels around the nation that use occupational licensing to prevent competition and new entrants. Is there an antitrust angle there?
Anybody want to take that?
I'm happy to go again. Sorry, it's a little awkward, other panels. I don't mean to jump in front of you. So just pull the plug if necessary. So, look, I think there's a bipartisan consensus that occupational licensing can go too far in protecting incumbents, and probably has in a lot of states, in a lot of professions. When I was actually on the Council of Economic Advisors, we were looking into this. There was a report filed. There's a lot of good work showing, my colleague Aaron Edlin here at Berkeley, showing the enormous increase in the number of professions that you have to have licenses to participate in, and how onerous it can be to get them. The problem for antitrust is we've got the state action doctrine. So if it's a state passing these rules, it's difficult, and it can be immune from antitrust. There was, I think, North Carolina was a dentist case where, in terms of if a licensing board is overly controlled by the industry and not by the state, then it can be subject to antitrust. So, but I think it's mostly a political thing for people to get out there and have their states not be so restrictive in this. So I wouldn't really, I guess you'd call it a cartel, but the real problem is state licensing. Of course, we do have health and safety issues, so I wouldn't, it's not like I'm suggesting throwing occupational licensing out, but it seems overly controlled by incumbents.
Yeah, go ahead.
So I want to respond to the point about your mom with the craft show. I also have a friend who sells her book on Amazon, and she was able to self-publish. So there are definitely examples like this. But I think the big platforms do take advantage of their power to charge significant prices for that. I'm not sure how profitable this business is for your mom. Certainly, if she started to get into something that was a threat to Amazon, I think it would be very easy for them to shut her down if they wanted to. So we need to maintain antitrust to keep track of those things and deal with those things if they happen. But I think there is still an incentive for large gatekeeper firms to not make it easy for small businesses that rely on them, but then at the same time are competing with them. I have been advocating actually that we need to look into this more. I've asked the FTC to do a 6B study. These are studies that the FTC can do where they can actually access non-public documents, which is really helpful. Advocates on the outside, we cannot do that, to see how big data is being used by these platforms in relation to these companies that are both customers and competitors. So I think that's an example of that.
Go ahead.
Well, I was going to mention at least one thing. The FTC currently is engaged in the Economic Liberty Task Force, which I think is actually really interesting, talking about this occupational licensing question I know you're aware of this as well. And I think that kind of soft pressure, which sometimes gets agencies into trouble, is actually probably pretty important in the occupational licensing space. We'll see how effective that is, because obviously at this current juncture, they're really just putting in, comments, it seems like regulatory comments, and, kind of just highlighting these problems within the FTC. But who knows if the local regulators are really paying attention that much to the FTC. But the other part of that, which is interesting, which is, undergirding a lot of this conversation, is that you have certain organizations who are very clearly dedicated to bringing local court cases. And you have places like the Institute for Justice and the Pacific Legal Foundation. So these groups have been very active in going after occupational licensing schemes at the state level. And a couple of colleagues of mine currently work at those organizations, and I think that they're doing very important work. So we'll see. I think that I'm actually quite optimistic on that level for occupational licensing. The kind of the platform question, I know that we have kind of touched around the platform question and whether or not platforms themselves, how they enable businesses and how they can potentially be detrimental to businesses. That, of course, needs to be, I think that the thrust of my comments here have really been that context matters a lot, and that it matters the kind of business you're talking about. It matters the platform that you're talking about. It matters even the changes that the platform might engage in that effectively disallow for them to reach certain kinds of constituencies. So I would, not to say that there couldn't necessarily be problems, but I'm just cautious that a lot of these problems that we seem to highlight and seem to talk extensively about, I think we just need context, and in fact some of these studies might be helpful to figure out what's actually going on at these at the platform level.
In the back.
Yeah, hi, Alec French with Thorson French Advocacy. I had a question. A couple of you addressed kind of the impacts on labor, and pointing out that I guess the consumer welfare standard is flexible enough to consider that, or that the horizontal merger guidelines do. But you mentioned that only in the context, I think, of anti-poaching agreements or non-competes. What about the scenarios where, when you have mergers, the removal of one competitor means less competition for workers, so holds down their wages, drives down wages, or even in the scenario of just organic growth, but where one company gets bigger, drives competitors out of business, and therefore has the ability to, because they're not competing, hold down wages? Does the consumer welfare standard allow for looking at the impact on wages of workers when there's less competition and there are fewer competitors in the marketplace?
Yeah, I dealt with that a little bit more in more detail in my paper, and I'd say that the antitrust law should protect workers, and can and hopefully does, when in the face of specific anti-competitive conduct, such as non-compete agreements. But it shouldn't protect workers when they lose their jobs because their company went out of business. Or it shouldn't protect workers when there's a merger that increases efficiency and makes a portion of jobs redundant, because you don't need to HR offices or whatever. Nor should it protect them through antitrust policy when they lose their job because of automation or other reasons that basically come because of the competitive pressure on companies to increase innovation, decrease prices, improve quality. Sure.
Wasn't quite the scenario I was talking about. You got two competitors.
Yeah.
One of them is bought by the other, and now because you don't have a competitor, you still need as many workers, but there's no competition, so you can hold down their wages. It's not about redundancy of jobs. There's no competitor for that labor anymore, so you can either pay them less or hold down wage growth because no one else is out there to hire them.
So that's very much covered by antitrust generally, Clayton Section 7, and the merger guidelines Section 12 lay out exactly this situation. And so first, if you have a merger between, it's called mergers of competing buyers, in this case, employers. Okay, so if there are really only two hospitals in town who hire nurses and they merge, and the nurse, and they're going to depress the wages of nurses, that's a problem in the nursing market. Of course, it's also likely to be a problem in that example in the product markets where the hospitals sell their services, okay? But it's definitely a problem by depressing the wages of nurses because nurses can no longer, shop around for a job, if you will. So unquestionably, that's covered. There are not very many cases of that historically. So I think that's an area where the agencies could look more. And basically, you're talking about local markets for particular professions, whether it's accountants, nurses, engineers, I don't care, because people don't find it so easy to move from one city to another. So I think these markets can be pretty localized. There's growing evidence that the concentration in local labor markets and that it can really affect wages. But you want to distinguish that from a situation where there's a merger, the company says, we're going to save a lot of money, cut costs, avoid duplication, save huge amounts of money, and we're going to reduce headcount, which of course the workers don't like at all. But unless there's a real reduction in competition for the workers, if it's just efficiencies and saving on costs, it's not going to be an antitrust problem. And the guidelines do lay out that distinction, which basically are the reductions in jobs a result, is it just efficiency or is it really a reduction in competition in the labor market? If it's the latter, totally fair game, and I'm glad to hear the FTC will be looking at that more.
The gentleman in the green.
Tom Struble, R Street Institute. It's refreshing to hear all the panelists recognize that the consumer welfare standard is a bit of a misnomer and can account for things like harms to labor, innovation, in addition to just price effects. But these are all sort of different things, but apples and oranges, so how you weigh them against each other is a bit unclear. So I guess in a hypothetical posed to the panel, if you have two merging parties and your economic models show that there's going to be a positive price effects, the merged entity would be able to deliver product or services at lower costs, increase output, but there's also a likely harm to innovation. How would you weigh the price effects against the innovation effects?
Like if we were a judge, or?
Sure.
Yeah, I think that would be a very tough situation for antitrust law to deal with. I think the price effects may diminish over time, so maybe I would focus more on the innovation effects. I think that has a longer term impact. If they were both shown to be the same somehow, that might be a way of distinguishing.
I'd say, in theory, you should be able to translate both of them into a common price effect and weigh them off against each other. It's very difficult to do because a lot of times you have data problems and modeling problems, but at least you have a clear guideline for how to measure them and what data to try and gather and what the scope of the investigation should be. In the neo-Brandeisian movement would have you consider a lot of other things besides price and the effect on immediate market participants, and there's no guideline for how to weigh those. So the problem would be much, much worse, and there'd be the guidelines would be looser, and the role for individual discrimination would increase if we broadened it even further.
If I could follow up, I think actually this illustrates why this is actually a really good example and question. I don't think the consumer welfare standard tells us very clearly whether price or innovation should be more important. But we know how to deal with these things in the law. There are plenty of other areas of the law that have multiple priorities, and we always find a way through the process of going to trial, of sort of analyzing those competing priorities and making sense of it.
Up front, the gentleman in the plaid checked.
Hi, I'm Mike Ducker from international development consulting firm called J.E. Austin. I just wanted to get back to the entrepreneurship point and how that affects maybe more competitive policy overall. I've also seen a lot of data around entrepreneurship, and I guess we have to distinguish between small business and entrepreneurs, because the people who are creating the growth, as I understand from Kaufman OECD, are the people who create 20%, 30% growth on an annual basis, who are the more innovators looking for new products, developing new services. They are not the mom and pop shops. So I think a lot of the problems often when we do this is small versus large aren't usually the best questions. It's usually these newer, more innovative firms, which might be 8-9% of small businesses, are really the ones that are going to create a lot of the innovations in the future. And so, and I don't think there's a lot of analysis that go into that slice the small business into that area. I think they, from innovation standpoint, I sort of disagree on some of the premises that they are not investing as much as the corporates. I would debate whether corporate R&D actually equals commercial innovation, and sometimes their corporate R&D is protective of their existing products through patent legislation, and they're just trying to grab more hold of the product, which other innovators cannot attack. And I think there's been some studies on that. I would also debate about political pressures. Yes, there are small business associations and car dealership associations and a lot of embedded groups that are protecting, I think, even older industries. I think even sometimes the labor and the auto industries or labor and aviation work together to protect newer industries. So I think there really hasn't been political power in newer industries. And I know there's groups coming up, and maybe some of them are here, they're trying to do that, but I think there is a political power with embedded players. I think if you look at trade policy, if you look at the Ex-Im Bank, I think all these organizations from a federal government policy are stifling sort of potential new innovators from that standpoint. So I do think the premise of we should just be happy large businesses are employing the majority of the people, they're creating the majority of the innovation. There's not as much innovative entrepreneurship like there was based on our historical presence. I think maybe we should, I don't buy into that premise quite a bit.
Thank you. Anybody want to respond?
So on the question of these kind of the differences between the two different firms, I've done a lot of work on the non-employer firms, or non-employer establishments as they're called, in the NES. So Small Business Administration actually has done some interesting work on this, the difference between these kind of effectively non-employer firms, which are non-employer establishments, to be very, very clear, which are actually about 75% of the economy, as compared to employing establishments which employ multiples of people, and typically within a 2 to 3 year period, and definitively within a 5 year period, you can tell those firms that are going to be quickly growing as compared to those firms that won't necessarily be growing at a clipped rate. So we have seen there actually has been some really, really interesting work on this. And I think we can connect later if you're interested in talking about that. The other part which you mentioned is this barriers to trade or barriers to entry question, which I think is actually quite important, and we're talking about this a lot. The one thing that I'd mention is that at least with the barriers to entry, starting up a new firm requires a whole bunch of, the one word for it is kind of intangible capital. It requires a lot of knowledge and know-how in a way it didn't require perhaps 30 or 40 years ago. So that to even start a firm, to start a new establishment, you really do need to have some sort of knowledge base. This is why we've seen most, entrepreneurs, people who are starting up, getting older, they're in their, late 40s, early 50s. We also see that this is partly the reason why you have these kind of serial entrepreneurs, people who are able to start a firm, and those firms that they are then able to, start and then create a new firm, that they're actually quite effective in productivity. So I think it's just getting harder, generally speaking, to create an important and productive firm. That doesn't necessarily mean that competition has decreased, which I think is a lot of what we're talking about. And in fact, it is indicative that it's a very competitive market, and you have to be able to create something that's new and productive to even be a major player. So, to me, the picture is just very muddled at the end of the day.
Well, I do think it's definitely something that we need to look at more, and is not completely clear. But I think another one of the sort of intangible things that you need to start a business in a lot of industries is connections or some way to sort of work with this thicket of larger companies that are sort of between entrepreneurs and their ability to get to their customers in internet, in e-commerce. I think that's an issue that a lot of new entrants have to deal with, and those companies do not have an obligation to work with you. So that could be part of it as well, although we do need more research.
Gentleman in the front, and we'll go to the back.
Thanks. I had a question about terminology. So when we talk about harm, like economic harm, consumer harm in the antitrust world, it's very different from when we talk about harm in criminal and civil liability. So if I punch Will in the face or I steal his wallet, which I'm not planning on doing after this.
Not yet.
I've definitely committed an arguable harm that I could be held liable for, both criminally and civilly. But if I sell him a bagel every day, and then one day for $1, and I change my price to $2 the next day, by economic analysis, he's worse off, because now he's paying twice as much for the same thing. But I haven't violated his rights by doing that. So maybe not for the people in this room, but I think maybe for some people, non-experts, referring to the economic, quote, harm that comes from some of these business practices that are not individually invidious. Like, if I raise a price, I can do that. That those two things get conflated with someone violating your rights and doing something that should be legally wrong, or making a decision, a standard business decision, that just ends up not benefiting you economically as much as might otherwise be.
Go ahead. I'd say it's a good analysis, but I'd say in response, it depends upon why. It depends upon how you played the game and the competitive game. So if you don't have any market power, but you're still able for whatever reason to raise the price, that's okay. You're playing by the game. But if you're skewing the rules and somehow you've acquired market, a dominance in a market, and you're using that dominance to increase prices, then antitrust policy would come into play. And so it's really, from Will's point of view, have you violated the rules of the game, of the competitive process? And if you haven't, then he hasn't suffered any real harm to off-balance your gain. If you have, if the market as a whole is less competitive for everybody, then antitrust policy would say you have violated his rights and he has suffered a real loss, I think.
The one thing I was going to... You're exactly right, and this actually presents... I'm trying to actually find it. There is a report that came out looking at exactly this question, which is trying to understand consumer harm, and how we actually, when we do a lot of the retrospective merger reviews, how we actually understand how consumers are harmed. That is actually a really key point, which is that if we're just looking at... if you're looking at how prices could be I don't want to butcher this, so I think we should talk about this offline. But what you've laid out is actually a really a key fundamental problem within even understanding what the competitive effects and how, even within the merger reviews, how effective that they have been, or how we understand consumer harm. I think you're exactly right. This actually is a kind of a key problem.
The gentleman in the back, and then we'll go to this gentleman here, and that'll be the final question, I think.
Hi, I'm Ryan Bandarian from Third Way, Economic Policy Advisor. I know that Will and Charlotte touched on the issue of vertical integration. We're talking about like platforms being the supplier of the platform and also competitors on it, but I'm wondering more specifically, how does the consumer welfare standard take into account issues of vertical integration surrounding competition? Obviously, with Google and the fine that they just got from the European Union, it's hard to say that any consumers are being made worse off by seeing Google's own products before other competitors' products, but at the same time, it's also hard to argue that that doesn't pose a serious threat to competition going forward. So I'm wondering how the consumer welfare standard accounts for these types of things.
Carol, do you want to take that one, Carol? And maybe if you do, maybe you could also comment on the way that the EC interpretation of antitrust is maybe diverging from the past and from the U.S. model.
Sure. I guess I should say I do some work for Google involving their European entanglements. So I'll disclose that. The fact that from the consumer's point of view, Google's free in terms of it'll pay money, it doesn't get us very far at all in terms of antitrust. There can still be consumer harms, could come in the form of the data we have to give. People worry about that. Or potentially stifling other, if we're getting biased information, the service isn't as good and we're missing other opportunities. Yelp is a main complainant against Google, for example. They claim that. So they can have other forms of harm. And also, again, the consumer welfare standard, if the competitive process has been disrupted, even if we can't identify the specific harm, that's of concern to antitrust. If somebody's, Google in this case, would be using if they're using a dominant position to exclude rivals who could grow into stronger competitors and offer services, that's a concern as well. Even though it might be very hard to measure any harm in the short run. Okay, so because that's too tough a standard in my view for let's say the government to do something here. Okay, now it didn't sound so far like I was doing work for Google, I think, but I disclosed that. The problem arises. Where it gets harder, I think, though, is to normally, and anytime you have a dominant firm with with allegations of exclusionary conduct, there's a business justification defense. For example, Google says, "Look, we're providing, we think the best information. We're designing our algorithm." So it's very hard in the U.S. context for anybody, a government or private party, to challenge that. They'd have to show, no, you didn't design your algorithm, in a way that was good for consumers. That's a tough burden for a plaintiff to show. In Europe, they've got actually they're not claiming bias of Google's algorithm. They're claiming some other thing having to do with the shopping that's more obscure. But I don't think she got hung up anyhow on the free aspect. Okay, the question is: are these companies, these powerful platform companies, are they using that power to provide better services and compete in that way, or are they using it to exclude competitors? Okay, and as they get vertically integrated into other lines of business, then we get this tension between companies that are both kind of customers and competitors at the same time. Amazon is facing that in the European Commission as well. And there's definitely a much broader view, or at least a significantly broader view of what could be a violation in Europe than the U.S. under current law. But the U.S. we could change that if we wanted to. I'm not sure it would be wise within the consumer welfare standard.
Okay, so I'm told we're out of time. Yep. So I want to thank you all for coming. I want to thank our panelists for their comments. And please come again to the ITIF events. You can see our future events at itif.org. Thank you very much.